like the gentleman from Minnesota, I'm also a farmer. But unlike him, I cannot hope and wait to see what you guys are going to come up with. I can't take hope to the bank. And so I'm very concerned about this. It affects the livelihood of our community, of our state, the largest ag state in the nation that is feeling some of this pain already due to Army Corps and some of the challenges they've already put on some of the fallowed fields that are now having some water on those fields. And I'm concerned that this year, because of government, when water gets shut off to the Central Valley, 1 million acres of farmland could be lost. Now, it might rain next year, and we may have, with the fallowed fields, may have some puddles that, or ponds, that, or even some streams that end up going through 1 million acres of lost productivity, of lost jobs. So, yeah, I've got a lot of questions about this. Let me start with you, Ms. Darcy. Because of the ambiguity of this rule, do you think it's going to encourage third-party lawsuits?
I actually think that this proposed rule will bring additional clarity to the jurisdictional determinations that are necessary under the Clean Water Act. So I think with additional clarity, there will be fewer lawsuits.
So you think that this new rulemaking will create less lawsuits?
I do.
And greater clarity?
I do.
Now, the permits that are going to be required, how long do you think it'll take to issue a permit?
Congressman, it depends on what the permit's being asked for, you know, and you know how much information we have up front for that particular permit. It does vary. It varies from region to region. We try to do our permits, whether it's, we have individual permits, we have nationwide permits. Nationwide permits are usually go more quickly than individual permits because individual permits usually require more data and more information.
If it's a area of farmland that's been historically farmed but may have sat fallow for a year or two and now is required to do a permit, how long do you think it would take to do a permit?
Congressman, what you've described would be prior converted cropland that is exempt from the Clean Water Act.
Well, I will circle back around with you because I've got a number of constituents that have these very same concerns today, that are unable to farm, that are losing a season of planting, that can't go back through and farm that property, and again, seeing that job loss in our community. Let me ask about the Clean Water Act. In 74, when this was originally done, it was done with navigable waters with ebbs and flows of the tide. Now we're seeing ebbs and flows on our riverbanks because of discharges from government forcing discharges. What we see in the Central Valley are these pulse flows. These pulse flows not only go down the river, but they overflow into the farmland that is adjacent to it, sometimes losing the crop, but sometimes forming a pond or a puddle or a mud hole that now could be under this very same thing. So my question is both on navigable waters as well as intrastate waters, where now EPA and the Corps would have jurisdiction over.
Under current law, we have jurisdiction over navigable waters.
Intrastate waters?
Yes.
What about groundwater?
No.
Mr. Presepi, you talked about pollution. Is fertilizer a pollution?
Properly applied?
Probably.
No.
What about pesticides?
Pesticides require have to be applied according to the label, and they would fall under a general permit if they apply it on water.
So again,
but not when a field is flooded. If I can think where you're going, that would not.
That's exactly where I'm going, and that's the concern that a number of our farmers have.
It would not change That would not change because a flooded field is not jurisdictional.
Yeah, but if you fallow a field and you're unable to plant for a year or 2 years or 4 years, and a pond or a something that is already covered under your own definition now gets pesticides or herbicides or fertilizer in it, that would be a pollutant, would it not?
Boy, The general permit for pesticide application under the Clean Water Act requires the avoidance of spraying directly on waters. If there is a crop and you spray on the crop, it does not need a permit, or it does not fall under that.
So it would fall under that if you were spraying your crop and it went into that water, even though it's not into a river or a stream, but it was considered an adjacent water on a farmer's field.
The water on a farmer's field is not jurisdictional.
Not if it's flooding, but if it is accumulated water, it is under this definition, would it not?
I don't think so.
Well, then why couldn't you answer Mr. Young's question about a pond? I mean, we're talking about farmland here.
I would have answered Mr. Young's question, but I didn't get a moment. That's all. I don't mean anything by that. He could drain his pond if he wants to. Doesn't require a permit under the Clean Water Act.
Thank you, Mr. Chairman. I got a number of other questions, but I'll wait for the next round.
Ms.